Have you ever seen a neighborhood fight get completely out of hand? Well, today we're diving into a wild one. It's all about a single security gate, but it explodes into this huge legal battle over, get this, one single, super confusing sentence. And what seems like a tiny local spat actually opens up these massive questions about safety, about community rules, and, who really gets to call the shots. So this whole thing kicks off with a bang, and I mean literally. Picture this, a hearing, and the lawyer for the HOA stands up and paints this incredibly dramatic scene. For the board, see, this isn't just about some gate. They're arguing it's about protecting their entire community from some really serious stuff, especially since they're only about 30 miles from the Mexican border. Okay, so that's the setup. The HOA board, worried about all this, decides we need a security gate. Simple enough, right? Wrong. Two homeowners, Fink and Brittany Oleson, step up and file a formal complaint. And their argument is simple and powerful. The vote you used to approve this gate, it was totally illegal. Now, what's so interesting here is that the homeowner's complaint is super specific. They're not even debating if the gate is a good or bad idea. Nope. They are laser focused on one thing and one thing only, the rules. They're saying, hey, your own rulebook requires a 3/4 supermajority for a project like this, and you guys, you just blew right past it. So to figure out who's actually right here, we've got to put on our detective hats. And the number one piece of evidence, the smoking gun, if you will, is the community's official rulebook. This one document is what this whole messy fight really boils down to. And that rulebook has a name, the CC&Rs. That stands for Covenants, Conditions, and Restrictions. Basically, it's the list of rules everyone agrees to follow when they buy a house there. And you gotta understand, under Arizona law, this isn't just a friendly suggestion. It's a rock-solid, legally binding contract between every homeowner and the HOA. Okay, you ready for this? Here it is, the sentence. The entire case hangs on these 48 words from Article 2, Section 1C. And I'm not kidding, it is a grammatical nightmare. It tries to link two totally different ideas together, making improvements and increasing the number of houses. And how those two ideas are connected, well, that's the million-dollar question, isn't it? So to try and make sense of this mess, one of the homeowners, Fink, came up with this absolutely brilliant analogy. It was kind of a mic drop moment in the hearing. He created a new sentence with the exact same confusing structure. And his point was, look, if we use the HOA's logic, then my lawnmower must be filled with water and plastic flakes. It was such a clever way to show how absurd their interpretation was and argue that the two parts of the rule are completely separate. All right, so we've wrestled with the rule in all its confusing glory. Now, let's look at the second major piece of evidence, the cold, hard math. Let's just break down the vote, shall we? First off, in this community, you've got a total of 39 eligible lots that can vote. So, if you do the math on that 3/4 rule that the homeowners are talking about, well, that means you need 30 yes votes for the gate to be approved. Simple as that. And how many votes did they actually get? The final tally was just 27. So, when you lay it out like this, the numbers don't lie, right? They were short by 3 votes. For the homeowners, this must have felt like an open and shut case. But, as you can probably guess, it was anything but. And that brings us to the big question, right? If the math is so clear, how on earth did the HOA declare victory and start building the gate anyway? Well, it all goes back to that one single confusing sentence. They just interpreted it in a completely different way. So let's put these two arguments side by side. On the one hand, you have the homeowners who are saying the rule is simple. It applies to any improvement on common property, period. But on the other hand, the HOA is saying, no, that 3/4 rule only kicks in for a very specific kind of improvement, one that also adds more houses to the neighborhood. And since a gate doesn't do that, they argue the whole 3/4 rule is irrelevant. Okay, so to back up their argument, the board did what you'd expect. They went and got legal advice. And folks, this is where the story goes from just a dispute to something truly bizarre. Just look at this timeline. Back in 2014, they were talking about a similar gate, and their attorney, a guy named Kramer, said, yep, you need a 3/4 vote. Fast forward to 2023, the board goes back to the very same attorney, and he gives them the complete opposite advice, says the 3/4 vote isn't needed. And to top it all off, a second lawyer they hired basically just dodged the key question entirely. You can't make this stuff up. And if you think that's wild, it gets even murkier. The homeowners actually dug up evidence that the board went shopping for a third legal opinion. They found an email from a board member that basically quotes this new lawyer saying, and I'm quoting here, "The petitioner is correct." That means the homeowners were right. But, and this is a huge but, the judge blocked that email from being used as evidence because of attorney-client privilege. Okay, let's just take a step back for a second. We've got a fight over grammar, lawyers contradicting themselves, maybe even a secret legal opinion. This tiny little neighborhood dispute is like a perfect little microcosm of the huge conflicts that are playing out in communities all over the country. Even the judge pointed this out. Despite all the really emotional arguments about crime and safety, she had to remind everyone, look, my job here isn't to decide if this gate is a good idea or not. Her job was much, much narrower. It was simply to decide, did the board break this one specific rule, yes or no? And that's what makes this case so fascinating. It really lays bare these universal conflicts, doesn't it? It's that classic battle between the letter of the law versus the spirit of the law. It's about being a stickler for the rules versus a board feeling like they have a duty to act and protect people. And man, does it ever show the power and the danger of just a little bit of ambiguous language in the documents that govern the, 74 million Americans living in these communities? So at the end of the day, it leaves us all with this really tough question. When the rules are foggy, when they're unclear, who gets the final say? Should it be the precise, maybe outdated wording of a contract? Or should it be the judgment of a board, elected by the residents, that's trying to deal with problems in the here and now? There really is no easy answer to that, and it's a question that thousands of communities just like this one are wrestling with every single day.